Mr. Chief Justice, and may it please the Court. Your Honors, my name is Mike Gardner, and I represent R.F. Noorani, the respondent in this matter. Your Honors, the continued presence of the Latin cross on Sunshine Rock violates the Establishment Clause of the First Amendment to the United States Constitution for three reasons. First, because it fails the Lemon test, which is the test that should govern this case. Second, because the government land transfer is an ineffective cure of that Establishment Clause violation and itself violates Lemon. Third, should this Court accept the lower court concurrence's invitation to rework its Establishment Clause jurisprudence, the facts of this case should still create a violation because they run contrary to basic First Amendment Establishment Clause principles.
So because we're nearing the Halloween holiday, you want us to continue to respect the ghoul in the late-night horror movie?
Your Honors, Justice Scalia's colorful analogies aside, the test that petitioner would have you enforce, the Van Orden test, has never commanded a majority of this Court. It has only commanded a plurality in one case.
But that's the same, that argument isn't much better than the argument, well, we shouldn't look at the endorsement analysis of Justice O'Connor because it's only the concurring opinion. I know I've heard a very brilliant jurist argue that here this evening, but I mean, everybody does look at it, don't they? So it's our most recent statement, and it completely ignores Lemon.
Your Honor, the most consistent analysis that this Court has applied is Lemon, and it has been criticized for its recent inconsistency in the adoption of the endorsement test from Justice O'Connor's concurrence in Lynch. However,
isn't the truth of the matter we use Lemon where it works and we ignore it where it doesn't?
That is a general criticism of Lemon, but it is slightly overstated because the endorsement test is actually a subset of the Lemon analysis. If you look at Justice O'Connor's language in her concurrence, she stated that endorsement clarifies Lemon because under the first prong of Lemon, we look to whether the government has purposefully endorsed religion, and under the second prong of Lemon, we look to whether the primary effect, irrespective of the government's intent, gives the effect of endorsing religion from the perspective of a reasonable observer. So, Your Honor, if we can proceed to the Lemon analysis.
So you'll be comfortable if we apply the endorsement test purporting to apply Lemon?
Your Honor, it's Respondent's position that that is the intent of that was the intent of Justice O'Connor when she conceived of the endorsement test in her concurrence.
She only had one vote.
Yes, Your Honor, but the Court has since adopted that test on multiple occasions as a subset of Lemon.
Not as a substitute for the second prong of Lemon, counsel.
Your Honor, to the first prong of Lemon, then.
And I don't know why you would contend that anyway. That undermines your argument just like it did your colleagues.
Your Honor, irrespective of the relationship between Lemon and endorsement, the facts of this case create a violation of both, so we can examine them separately. We'll begin with Lemon. Under the first prong of Lemon, the government has to have a secular purpose for its action. And here, if we look at the analysis under McCreary against ACLU, the government action the secular purpose of the government's action cannot be a sham, nor can it be secondary to a primarily religious objective. Here, if you look at the facts of the case, this cross may have had an ostensibly secular birth, but since 1 year after its founding, there have been Easter sunrise services held at this cross every year, and the record does not indicate any evidence of individuals gathering for secular honoring of the war's dead.
Well, then you're in hot water already on the secular purpose prong. I mean, you just conceded that not only that it has a secular purpose, but that from its inception it was the secular purpose, and you're advancing here to an unheard of argument, to my knowledge, that the purpose for its origination can somehow change over time depending upon the use that it's given by the public.
Your Honor, the VFW claimed that this cross had a secular purpose when they installed it. Respondent does not contend that that secular purpose actually existed.
Yes, you did.
Your Honor,
we'll have the bailiff read the transcript back.
Apologies. When counsel said ostensibly, perhaps he chose his words poorly. The VFW claimed that it had a secular purpose. However, as Justice Souter has observed in his concurrence in Capitol Square Review and Advisory Board against Spinet, a Latin cross standing alone can never be reasonably taken to have a secular purpose. Now, however, Respondent will not concede the secular purpose prong, but should this Court find a legitimate primary secular purpose, it is not fatal to respondent's case because the second prong of Lemon is also violated. And here, the government's action creates the effect of favoring religion in the eyes of...
Well, it's certainly not its primary effect, and that's the formulation of Lemon.
Your Honor, the primary effect of a Latin cross sitting alone atop a huge outcropping, a huge rock on one of the primary access points into this federal preserve would have the effect of the government preferring one religion over another religion and religion over non-religion.
Is that what goes on in Arlington Cemetery?
Your Honor, in Arlington Seminary, there is a large variety of symbols, and those who are allowed to be interred there, their families can actually choose which symbol are put on their tombstones, whether they are religious or non-religious. And so you have a wide variety of symbols, and this court has always found that with the existence of a wide variety of symbols in close proximity, the government is only acknowledging the role that religion plays in the lives of American citizens. And so...
also here, but better, because it's the memorial for the slain.
Your Honor, the reasonable observer would have no way of knowing that. Petitioner states that the reasonable observer would know the legislative history...
Well, no, because that's the import of your having conceded the secular purpose. The reasonable observer would know that.
Your Honor, this court has in the past given quite a bit of knowledge to the reasonable observer. However, from an everyday citizen's perspective, if they come to visit the Federal Preserve, they come in on one of the main access roads, and they see a cross standing at one of the main points in the Federal Preserve.
How do they know that it's on federal land?
Because, Your Honor, this is 1.6 million acres of federal property, 90% of which is federally owned.
There are 1,800 acres of privately owned acres, correct?
Indeed, Your Honor, out of 1.6 million. Additionally,
nevertheless, they're there.
They are there, absolutely. Additionally, however, the area around the base of the rock is a popular camping spot, which indicates that this is public property. And so this culmination of evidence would put forth to reasonable observers that the government has chosen to accept the Christian tradition.
Counsel, what if the government put up a sign that said, "End public land"?
Your Honor, if it actually did end public land, then that case would be somewhat similar to the Seventh Circuit's case, Mercier against Fraternal Order of the Eagles, where there were 2 fences and 6 signs surrounding the Ten Commandments display in a public park. However, this is public property, and the government transfer has failed to cure that violation. Because
what if there was signage on the highway coming into the preserve that said the cross that you see is owned by the VFW?
Your Honors, even in as the Ninth Circuit has observed in separation from church and state against City of Eugene, even where there is a sign indicating that this cross serves as a memorial, the classification of a war memorial does not cure the Establishment Clause violation. And so what the government has tried to do is cure through a land transfer.
That was not the significance of Justice Keeley's question. She wasn't asking whether that would cure. She was talking about if you placed a sign, could the reasonable observer ever think that there's government involvement?
Your Honor, the reasonable observer would see that the government has allowed leeway for private individuals to erect a permanent sectarian symbol on federal property, which is in violation of 36 CFR Section 2.62a, which bans the installation of any private symbols on federal parklands.
Well, you can argue that after we reverse the Court of Appeals here on the Establishment Clause issue.
Your Honors, respectfully.
We limited the question presented to the constitutional one, not the Federal Register one.
Yes, Your Honor. Counsel's point was that the reasonable observer would see the leeway that the government has granted for one specific religion, which it did not grant for another one, the Buddhist stupa that applied to be installed. And now, to try and rid themselves of this entire problem, they have attempted a land transfer which doesn't actually transfer the land. Instead of simply giving title or doing a fair transfer, they have first, remember that this cross was about to be taken down, but Congress acted and the cross stayed in place. Then they designated it a national memorial, putting it in such company as the Washington Monument and Mount Rushmore. Then they enacted a land transfer, which has a reversionary clause, which keeps government control over the VFW and doesn't allow them to have the full ownership rights that traditional owners would, and under Section...
Where do you get that interpretation? As long as the VFW maintains the war memorial, Congress has nothing to say about it, and federal government has nothing to say about it. It's only if it ceases to be a war memorial that the reversionary clause takes effect. Isn't that correct?
Your Honor,
in that way, Congress is probably protecting against an establishment of religion at its own hands.
Your Honor, in Hampton against City of Jacksonville and Eaton against Grubbs, the Fifth and Fourth Circuits, respectively, examined land transfers where the government sold land to private parties but retained a reversionary clause. And in both of those cases, the land transfers were invalidated because it said that the private parties could only act in the shadow of the reversionary clause, which, like this current one, required the private parties to maintain the property as it is. And so we have a current problem with the reversionary clause because the VFW doesn't know what the discretion of the Secretary will be. What it does know is that the status quo appears to work. And so that ensures that the cross will remain, and it removes the rights of the VFW to fully exercise their ownership. Further,
I'm not sure that we would even have a case or controversy on the reversionary aspect of this until such time, as Justice Keeley says, it is or is not invoked. So if we say as a matter of constitutional law that the presence of the cross does not violate the Establishment Clause, then we would say to another day the question of the congressional action. Would we not?
Your Honor, if the...
You can bring it later, and when it's ripe, it wouldn't be ripe right now.
The reason there's a current issue is because the reversionary clause exercises a current impetus on the VFW to keep things as they are. And further, under 16 United States Code, sections 1 through 3, the United States is required to maintain all national parks and memorials and monuments. And so
you couldn't go into federal court and get an injunction today on the reversionary provision based upon the argument you just made, could you?
Your Honor...
Of course not.
Your Honor, Respondent argues that the culmination of all of these aspects of the land transfer, the immediate cessation of the attempt by the NPS to remove the cross, the designation as a national memorial, the method of transfer, which did not employ an open bid and went directly to the interested party, the reversionary clause, and the duty of the United States to maintain national memorials all create what is effectively a straw purchaser situation. The VFW does not have enough say in this deal to really exercise true ownership. However, Your Honors, should this Court decide that the current Establishment Clause jurisprudence leaves something to be desired and wishes to create a new set of guidelines or rules or tests, the facts of this case should still create a violation because they run contrary to the fundamental principle of the Establishment Clause, which this Court first stated in 1947 in Everson against Board of Education was the principle of neutrality. The government's...
That's certainly not what the clause itself says, is it?
No, Your Honor. However...
And we have not held in recent times that the government may not distinguish between religion and non-religion.
Respectfully, Your Honor, the first mention was in Everson against Board of Education. It has been mentioned again more recently in Lynch against Donnelly, Allegheny against ACLU, McCreary against ACLU. And so it does appear to be a touchstone of this Court's interpretation. And so when you look...
The best argument that we should look at the fact that although this is a passive display, it is only of the Latin cross. When you mention all these cases, you look at a distinguishing factor. We have always looked at what's the context. The government's argument here is the history and the context lead to a secular purpose. Not that the cross is secular, but that the purpose is secular. But the only symbol there is the cross. So that sort of puts you right into Van Orden. Even if we look there, can you distinguish the holding in Van Orden, the plurality holding in Van Orden, based on the fact that there's nothing else around this except the cross? It's just the cross.
Indeed, Your Honor. If you look at the history of the I'm sorry, my time is up. May I briefly conclude? If you look at the history of the Supreme Court cases where this Court discusses symbols on public property, in only one case has it upheld a symbol standing in isolation, and that was Capitol Square Review and Advisory Board against Bennett. And the reason it was allowed to stand is because it was in a traditional public forum and it was seen as free speech. Your Honor, my time is up. For the foregoing reasons, Respondent respectfully requests that you uphold the decisions of both lower courts. Thank you for your time.
Counsel.